Professor Gillian Triggs is the Dean of the Faculty of Law at Sydney University and an expert on international law. She advised the Humane Society International on its federal court case against a Japanese whaling company conducting hunts in Australia's whale sanctuary. And she joins me now in the studio. Professor Triggs, what will Australia's argument be to the International Court of Justice?
Well, the essential argument will be that Japan, like Australia, is a party to the International Convention on the Regulation of Whaling. And that, through that convention body, whaling has, since 1986, been effectively prohibited. There is now a moratorium, at least, on whaling of any kind, of any form of commercial whaling. So the essential argument by the Australian government is that the Japanese whaling is not permitted under that ban, and that the exception that Japan relies on, and that is scientific whaling, is in effect not genuinely scientific. That is the core of the argument. But other arguments rest on the other conventions, the Convention on the Trade of Endangered Species, in particular certain species of whale.
Now, I understand that this is not going to be a very quick process at The Hague. Can you explain a little bit about it?
Well, the court does give the parties quite a long time. The process has been Australia nearly a year ago submitted its application to the court. Both states are party to the court, so the jurisdiction shouldn't be a major problem. Australia then has had a while to produce the detail of its application. And that now will be submitted, I understand, in the next day or so, and Japan then has until March next year to present its side, and then the matter will go forward to the court, but it certainly will be a while.
So this case is really not going to have a material effect on Japanese whaling over the next couple of seasons, at least, you would think?
No, except that there is a possibility to apply for what's called an indication of preliminary measures. It's a very technical term, but what it's rather like is an injunction in domestic law, and you can stop the action, or the court can order that the action be stopped if there's any prejudice to a species, and that would certainly be possible. You could get action more quickly.
Is there any precedent for this type of case?
Oh, there are many precedents for indications of interim measures that the court is very happy to do and has done on a number of occasions, including, I might add, in the nuclear test case in 1973, which was the last time Australia brought a matter before the International Court. So we've not been litigious in that sense. Mm-hmm. There has been an interesting precedent for Australia's interest in fishing in the southern oceans, and that is the southern bluefin tuna case. And that was a case in which Japan was, Australia argued, taking more than it should do under the quota. And the matter was brought before the Law of the Sea Tribunal. But ultimately the question was whether or not the proper tribunal was in fact an arbitral tribunal under the much more narrow agreement on bluefin tuna. So Australia actually didn't come out of that quite as well as we would have liked, although a compromise was ultimately achieved, and that really is an ultimately a good outcome for both parties.
Now, I imagine when you take a case like this before the court, of course Australia runs the risk that the court may actually find some parts of Japan's whaling program legal, that we could actually go backwards in our fight to stop it.
Mm-hmm. That's a risk in any litigation, whether it's within a state or internationally in this before the World Court. It's always a risk that when you prepare your own case, you don't fully understand the strength of the other side. Of course, a good lawyer should, but one often doesn't. It is always a risk, and it might be that the court would take the view that in relation to some species, the moratorium has perhaps overreached itself. But I think from a strictly legal point of view, the Whaling Convention members have banned whaling. And unless you come within a scientific exception, that whaling would be illegal. The critical question is going to be, at least in that major part of the case, is whether or not the Japanese whaling is in fact scientific. And there's quite a lot of evidence to suggest that it's much more than scientific.
And do you think that this case will have any ramifications on relations between Australia and Japan?
Well, these kinds of cases tend not to spread out into other areas. We're an ally and a trading partner of Japan. Well, I believe that Australia reacted very generously in relation to the tsunami and the earthquake, and that was well received by Japan. I rather doubt that it would have any long-term impact. And I should say this disagreement between Australia and Japan has been going on for a couple of decades. So we've nonetheless managed to operate as friends and allies for quite a long time. Also, under the southern bluefin tuna case that I just mentioned, normal relations continue despite those disputes, and that's the way it ought to be. You simply put to one side the legal question, you resolve it using the legal mechanisms that are available, but they don't really affect the long-term relationships.
Well, perhaps good news for a long legal battle ahead. Thank you very much for joining me.
Thank you.